Hi, my name is Angel, and welcome to iHR Consulting FAQ. Today I'll talk about power of inspection and inquiry into complaints. First question, what does the powers of the inspecting officer or Director General, also known as DG, of Labor regarding the employment matter? The answer is, the inspecting officer or DG has the power to enter without any notice at all times any place of employment where the employees are employed in connection with employment matter within the provisions of the Employment Act. The Director General may take possession of such records where, in his opinion, the inspection, copying or the making of extracts from such records cannot reasonably be undertaken without taking possession of them. Such documents may be interfered with or destroyed unless he takes possession of them. Such documents may be needed as evidence in court. Second question, can an employee cease or leave his employer during the operation being carried on by the latter in relation to the inspection by the DG of Labor? The answer is, no, employee is allowed to leave or to cease performing any work on which he is engaged if his absence or cessation of such work would endanger life or property or seriously disrupt any operation being carried on. Third question, under what circumstances may the DG inquire into complaints made by an employee or an employer? The answer would be, the DG of Labor may inquire into, and decide any dispute between an employee and his employer concerning wages, or any other payment in case due to the employee under any term of the contract of service. Fourth question, how may the DG inquire into any claim made by the employer where the contract of service is terminated by the employee? The answer is, the DG may inquire into, and decide such claim on indemnity made by the employer, the indemnity of a sum equal to the wages payable to the employee during the term of the notice, or during the unexpired term of the notice. Fifth question, what is the penalty for offensing the work of the DG? The answer would be a person who fails to comply with a decision or an offense and is on conviction, liable to a fine of 10,000 ringgit or imprisonment for 1 year. Or both. In the case of a continuing offense, he is liable to a daily fine of Rs100 each day the offense continues after conviction. Last question, how does an employer commit an offense under the Employment Act? Well, an employer commits an offense if he 1. Fails to keep a register of employees required under Section 61, or to preserve the register for 6 years, 2. Destroys, alters or mutilates the said register, or causes or permits the register to be destroyed, altered or mutilated, 3. Fails to comply with any regulations provided under Section 62, 4. Fails, without reasonable cause, to forward to the DG returns as prescribed under Section 63 or forwards returns which contain any false particulars, 5. Fails to comply with the requirements of Section 64, which refers to an owner of any estate, mine or factory, 6. Refuses the DG of Labor access to any premises, 7. Assaults, obstruct, hinders or delays the DG of Labor for entering any premises, 8. Furnishes false information to the DG, and fails to cooperate,